Welcome to episode 27, Privacy Matters, How to Share Client Information While Staying Compliant with HIPAA and 42 CFR Part 2, by Nick Merkin, California healthcare attorney. From Clearly Clinical, learn, grow, shine.
Hello, everyone, and welcome. My name is Nick Merkin. I'm an attorney and compliance consultant in the healthcare space. And I'm here today to talk to you a little bit about HIPAA and some elements of that and best practices and what you need to know in the addiction treatment industry, as well as the applicability of what we know as 42 CFR Part 2, which are some additional regulations that at times and not always apply to those of us working in the addiction treatment industry. So we'll get into a little bit of that later on. So kind of as an overview, just to start things off, we'll talk about a little bit of HIPAA basics and, what HIPAA is all about and to whom and what kind of organizations or individuals HIPAA applies. Then we'll talk about a little bit of, what your responsibilities are under HIPAA as organizations in the addiction treatment industry. And that's going to include sort of affirmative obligations having to do with patient rights, and, responding to requests for information, as well as the sort of protections that you need in terms of protecting confidential information and various security kind of safeguards that the regulation and the government expects you to have in place. Then we'll round out by talking a little bit about breach and breach reporting, and then we'll have some things to say on 42 CFR Part 2. So let's jump right into things because we only have an hour. And as most of you probably know, HIPAA stands for the Health Insurance Portability and Accountability Act. It was it's a federal law, by the way, so it applies no matter what state you're in. And one thing I should mention as well is very often, depending on where you're located, there may be various state laws that apply as well. I obviously can't speak to, the whole spectrum of 50 states in this 1 hour lecture. But, you should make sure that in addition to HIPAA, that you're aware of your sort of local or state specific requirements and, you ask the right questions of a competent attorney or other kind of compliance expert, about what obligations you might have under that. But today we're going to focus, mainly on the federal overlay, which is known as HIPAA. So it was enacted in 1996 by Congress to develop regulations to protect the privacy and security of certain kinds of health information. And there are penalties for noncompliance, fines, monetary penalties, etc. And the enforcement agency that actually sort of oversees the implementation of HIPAA is called the OCR, the Office of Civil Rights, and it's a branch of the Department of Health and Human Services. And we're currently in phase 2 of an audit program that the OCR has in effect, where they're at certain times auditing various healthcare organizations for HIPAA compliance. So something to watch out for. It's not something that happens too often, and most addiction treatment organizations are on the smaller side of the healthcare spectrum. But if you do get involved in an OCR audit, it's something to take seriously and something that you want to make sure that you have the right expertise and knowledge in place to respond to. So let's continue on with HIPAA basics a little bit and some definitions, because there's a lot of jargon that gets used in HIPAA, and I want to make sure that we're all kind of speaking the same language. So first of all, there's something called a covered entity. And a covered entity is basically a healthcare provider. It can also be a health plan or a health insurer or what's called a healthcare clearinghouse. But for most of our purposes, that's going to be, an organization that delivers some kind of care. And that, addiction treatment organizations fall into that space. Slightly different than a covered entity is what we call a business associate. And so that's a third party that maintains or transmits or discloses or uses protected health information on behalf of a covered entity. And PHI stands for, or PHI constitutes individually identifiable health information that belongs to a patient. Sometimes you'll hear the term ePHI, and that really just means the same thing as PHI in electronic form. So two other sort of terms that I want to cover, and they may seem obvious, but one is use. And what does it mean to use PHI? So, use constitutes the sharing, applying, or examination or analysis of any kind of PHI within a covered entity. And disclosure is any kind of release or transfer or provision of access to PHI outside the covered entity holding that information. So those are important definitions to sort of keep in mind, because knowing when HIPAA applies and in what way it applies is going to be related to some of those definitions. So let's move forward with a little bit on who does HIPAA apply to. So we talked about both covered entities and business associates, right? So we're sort of square on what those definitions are. And, like I said, covered entities are in the main healthcare providers, and many of you work for those kinds of organizations. It should be said, by the way, although I'm trying to direct this talk to organizations and treatment facilities in the addiction treatment industry, a lot of what I'm saying really applies no matter what kind of healthcare organization you're working in. A lot would apply to skilled nursing facilities or hospitals, physician practices, etc. So if you're listening to this and you're not specifically involved in addiction treatment, stay with us, because a lot of this is going to apply to you. So let's talk about one concept, and that's the business associate agreement. So, a business associate agreement is essentially a contract that governs the use and disclosure and protection of information between a covered entity and a business associate. For example, you're an addiction treatment facility, maybe you're hiring an outside consultant, some kind of clinical director or something to come in and help with your programming. That clinical director, who's not part of your organization, would be a business associate. And HIPAA is going to require that you enter into what's called a business associate agreement with that individual or organization to ensure that the business associate is going to appropriately safeguard PHI. It's a real pitfall, by the way. A lot of organizations don't know this, or they skip this step. And it's something that, number one, in an audit, people are going to look at and make sure that, your vendors, your business associates that you're working with, you have valid business associates agreements with. And also, the business associate agreement protects you as a covered entity. It's not really just boilerplate, because it's going to govern the responsibilities that the business associates that you're working with have to you to protect information about patients that or clients that you're giving them. So, very important. So, we don't have time today to go through all the elements of what constitutes an effective business associate agreement. What I would say is, Various governmental agencies, specifically the Department of Health and Human Services, I believe, have sample business associates agreements on their website that you can use as a template. But, take what's written in there seriously. You may want to consult with an attorney before you make things, before you finalize a form. And, very often if you're working with another provider or a covered entity, they may have a form of business associate agreement that they want you to sign. That might be okay, but take care to read it and, make sure you truly understand what your rights are under it and what your responsibilities are under it as well. So let's move on a little bit to, to whom does HIPAA apply? So, I'm sorry, let me say it this way. We talked about, protected health information, and that's the kind of information that's going to be regulated and governed by HIPAA. So that's really a subset of all information, and it's even smaller subset of health information. Specifically, it's health information that's individually identifiable. It doesn't apply to de-identified information. And specifically with regard to HIPAA, it's going to apply to electronic protected health information. So, keep in mind that the definition of PHI, protected health information, is fairly broad. Basically anything that relates to the health of a patient, and that can be a recorded telephone call just about the time of an appointment. That could be things that make that information individually identifiable, like a date of birth, an address, a phone number. So the definition of PHI is rather broad, and probably on the safe side to be over-inclusive, but it doesn't apply to everything. Particularly what you're thinking about are items that are de-identified, where it would be, even if you disclose them, impossible to tell, which specific individual or patient they relate to. So keep that in mind. And, when you have a question, make sure that you're looking in the right places for answers, whether it's looking up a definition or talking to someone with expertise in the area. Let's talk about some more HIPAA requirements. And, that's the designation of a HIPAA privacy and security officer. In many organizations, particularly ones that are of a relatively small size, and I should say healthcare organizations of relatively small size, and that's going to encompass, I think, a lot of addiction treatment kind of facilities or individuals working in that space, are not going to have full-time HIPAA privacy and a separate security officer. But that being said, it is a good practice to have someone or it can be more than one person designated with that kind of responsibility. Just definitionally, the privacy officer is really the go-to person at the organization regarding things like HIPAA-related policies and procedures. That person might have, responsibilities for overseeing the process of receiving and documenting, tracking, and taking action on any kind of complaints regarding HIPAA that you might get, ensuring compliance with different kind of privacy practices, and then working with whomever is the HIPAA security officer to review, security plans and system-related information. A good practice, no matter what your size is to make sure that someone in your organization is wearing that hat and that it's someone that's qualified. And again, the security officer is a similar role, but really someone who's responsible for developing and updating information security requirements for the covered entity's PHI. That person's always going to work closely with HIPAA privacy officer, or again, might be the same person, but essentially they're going to make sure, and we'll talk a little bit about some of these security requirements later on in this hour, but they're basically going to make sure that things like administrative, physical, and technical safeguards are working properly within an organization. So, that's, again, it's sort of a major HIPAA requirement and a good best practice. Another issue is education, and some of this is what we're doing now, and the reason that many of you may be listening to this presentation. And what's required is HIPAA requires that there be an education of the workforce, whether they be staff, volunteers, etc., on HIPAA rules and regulations. So, all staff members really should be trained upon hire and then no less than annually thereafter. And one thing that I would caution is, document that training. That's really a job for the HIPAA privacy officer that we talked about. What you want to be able to do is prove a year from now, 2 years from now, 3 years from now, that your staff got that training. And, when it might come up is there could be a breach, and, we all sort of feel, well, it'll never happen to us, but, breaches happen. There's human error, there's hacking, there's phishing, there's all types of reasons that could cause a breach, even an honest mistake. But one of the ways that you're going to be able to, mitigate the problems, fines, penalties, anything else, and liability that might come from that breach is by being able to point to, well, we had a pretty robust training program, and here's all my training records for the last couple of years, proving to you that, yeah, although a staff person made a mistake, that person, was well trained, we did our best in good faith, but a mistake happened, human error, and that's going to go a long way. And I would say this for, just about everything we're talking about today. Make sure you document. If you have a HIPAA security officer, privacy officer, document that person's appointment, document that person's qualifications, document that person's role and responsibilities. Again, because you're going to want to use that as a defense in the case that there ever is a breach. Let's move on to a couple of other HIPAA requirements. And, we're moving kind of quickly over sort of, vast swaths of HIPAA, so to speak. But what I really want to do in this hour is give all of you who are listening a flavor of the different kind of practical requirements that are probably going to apply in your organization, and then give you the opportunity to, yourselves dig deeper into the specific requirements and the specific ways that you're going to implement those requirements within your organization. So another thing to talk about is what's called a notice of privacy practice. So that's a notice that the entity is going to give to patients, clients about their rights regarding the privacy of their PHI. The covered entity is required to give a notice to each patient upon admission, and each patient should sign an acknowledgement of receipt. Again, there are a lot of good templates you can use out there from very reputable organizations that you can find for your notice of privacy practices. But similarly to a business associate agreement, you want to make sure that you know what's in there, because that, again, is a document that is going to govern some of your obligations as an organization to a patient, and promise a lot of the safeguards, that patients are required to be given under HIPAA. And you want to make sure, you know what those promises are and that you're effectively able to deliver on those. A couple of other just nits: you should, post publicly your notice of privacy practice, somewhere probably close to the admissions area of your organization. And it should really be accessible on your website as well. So, again, things to keep in mind. It's a little bit of a check the box thing, but, one of the things that I want to underscore to all of you who are listening is, there's a lot of paperwork and there's a lot of documents in HIPAA and in other areas of compliance as well. It's a good idea to, know what you're saying, and because you're making promises and you're accepting obligations, in those documents. So, these aren't necessarily one size fits all for all organizations. And, it makes me nervous as an attorney when I see that one organization has adopted either a business associate agreement or a notice of privacy practices or even just a whole set of HIPAA policies and procedures from an organization that's just completely differently situated than them, because chances are there's going to be a lot of things in there that aren't going to have universal application, and you're going to want to be careful, about promises you're making. So let's talk a little bit about uses and disclosure of PHI. So, a covered entity in general can disclose PHI without the patron's authorization when the information is used to facilitate things in 3 different areas. And those areas are treatment, payment, or healthcare operations. So, there's other sort of more minor exceptions, like public health activities and where there's abuse, neglect, and domestic violence, and things that you should be aware of. And, those are the kinds of things that your either corporate compliance officer or whoever's your, HIPAA privacy compliance officer, should be more aware of. But generally speaking, any disclosure of PHI outside of those areas of treatment, payment, or healthcare operations are going to require the entity or the organization to obtain a written authorization from the patient before that disclosure. And it's important to get it in writing. It's important that the disclosure take a certain form. And I should caution you, there are federal rules under HIPAA about, what a disclosure needs to contain. And in California, for example, and I know in many other states, there are specific state laws pertaining to your disclosure forms. So, make sure in your locality what the specifics of disclosure requirements are in terms of documentation and that you're following those. So, a couple things just to keep in mind. And, in general, the forms are going to have a clear description of the information to be disclosed. They're going to talk about the purpose of the request for disclosure. They may have an expiration date of the authorization, and they're going to talk a little bit about the patient's rights with respect to the organization. It's also important to realize that a patient can revoke his or her authorization at any times. And, you need to keep your ducks in a row and your documentation straight about these things, because one of the major areas that I see organizations getting in trouble with HIPAA breaches is not necessarily an accidental breach or one of the things you see on TV or read about in the papers, where there's some, massive hack going on. But it's the little things. It's, losing track of what I need to obtain a disclosure for, the validity of that disclosure, how long, to whom the information may be disclosed to, and violating HIPAA rules because of that. And it's an easy way to just get caught up in something. And, I'm sure it goes without saying to many of us, we work in a field in addiction treatment where, the privacy of our clients is really paramount. In some ways, probably even more acutely so than in more general areas of healthcare. And those are for obvious reasons, the nature of addiction and, not wanting, even close family members at times to know the extent of, what the client may be going through. And the client may have all sorts of reasons they want to maintain privacy, including employment, including from even their insurance company for various reasons. So, HIPAA in general, and specifically voluntary disclosures of PHI are something, to be taken very, very seriously in any area of healthcare. And I would argue, even specifically, in the addiction treatment world. Let's move on to a different concept. And that's what's called the minimum necessary standard. And so there's a standard called the minimum necessary standard that applies whenever an organization is making use of PHI. And keep in mind, this is in a situation or in situations where because a HIPAA exception applies, like treatment, payment, or operations, individuals in the organizations have every right and even a responsibility to examine or analyze a patient's PHI. But the principle still applies that the covered entity should only use or disclose the minimum necessary amount of information in order to achieve their purpose. So, for example, and I'll give some examples just, in general in healthcare. If nursing staff is assigned to a particular nursing station, they should only be authorized to access information for patients that they're treating at that station. To extend that example to the addiction treatment setting, you may be a counselor and you may not be assigned to every single client in your organization. Your access to PHI should really only be limited to what you need to deliver the kind of care that's necessary for your particular patients. It's actually a very important standard and something that really has to underlie anything you're doing with PHI. And believe it or not, it's actually a breach to exceed the minimum necessary standard, even if you're a bona fide employee of the healthcare organization and that organization has a general right to look at PHI. Some of you may remember a few years back, a particular celebrity's PHI was viewed by healthcare workers at UCLA, and it created a big scandal for the hospital system because this patient was a celebrity, and there were individuals within UCLA healthcare who, for voyeurism or for whatever reason, wanted to check out that celebrity's healthcare information, and they did so, and they wound up getting fired, and it became an embarrassment for UCLA. So that's just an example of kind of something that seems simple, but a standard that has to be upheld in the minimum necessary to standard. A couple of other just nits about disclosure of PHI. Number one, the disclosure should be tracked. So anytime you're, outside of normal treatment, payment, or operations, disclosing PHI to a party outside of your organization, obviously with the patient's permission, you should be tracking those disclosures in writing, who you're giving it to, when, what the extent of the PHI release was. You should keep an accounting of that for at least 6 years. Again, a job for the HIPAA privacy officer. And that's really because a patient can request an accounting of their disclosure from you, and you have to give them that information. So keep that in mind. And, with that, let's move a little bit on to the concept of patient rights. We often think of HIPAA as like sort of a list of thou shalt nots, right? Thou shalt not disclose this, thou shalt not disclose that. Actually, there's, the other half of HIPAA, so to speak, is about what rights of access to PHI that patients have. And it's an important right because actually not giving a patient or a client access to his or her PHI within a reasonable amount of time might be a HIPAA violation in and of itself. So, a patient in a general sense, and, again, I keep cautioning this at every turn, there are going to be some specific state laws depending on your locality that might apply to this. It might change some of the timings. It might change some of the responsibilities that you have as an organization to give access to PHI and other rights to patients. Make sure you have those in mind. So, a patient has a general right to access their PHI by submitting a written request or an oral request to the covered entity. They can request to inspect it, to get a copy of it, to get a summary of their PHI. Make sure you're taking those requests seriously, making sure you're documenting them. They have a right to, if it's ePHI, the patient can specify the form and format they want it in. Under HIPAA at least, there's you have a 24 hours to respond to a request for access to PHI and 48 hours to respond to a request for a copy of a patient's PHI. So the deadlines are pretty tight. So, make sure that from an operational perspective in your organization, you have, the policies in effect and in place that's going to allow you to be responsive to that. And, there are reasons that you can deny PHI, and you have to make sure that you're only giving access to PHI that's appropriate under HIPAA. The details of that are a little bit too broad for, or I should say a little bit too specific for discussion today, but, again, something to keep in mind. Another issue is amendment of PHI. Patients have a right to amend their PHI if something is inaccurate in their record. They've got to submit that request in writing to you, and you get only 30 days to respond. It's something that does come up, particularly in the addiction treatment space, because sometimes there is information that can be put in PHI that the patient feels is unfair or untrue, and that might affect their insurance coverage. That might affect something that a future healthcare provider sees or a family member sees. So it actually does come up. Obviously, you only make the amendment if it's appropriate and there's actually an inaccuracy in the patient's record. But it's something to take seriously and something that does come up in the addiction treatment space. One or two other things to mention that come up from time to time in the addiction treatment world. One is a patient has a right to ask for a restriction on disclosure. So even if it's for one of the permitted reasons like treatment, payment, and operations, if there's an appropriate reason, the patient can say, I don't want my healthcare information released to, let's say a certain provider. Or they can even say that there, might be a certain staff member that they don't feel comfortable with having access to their BHI. They're allowed to request that. I mean, there are some limitations to what they can request on practicality and appropriateness. But in a general sense, patients have the right to agree or object to the uses and disclosures of PHI, even if those uses and disclosures are otherwise appropriate. They may not want to be listed in some kind of directory. They may not want to, give out information as to the location or general health condition to certain physicians for whatever reasons. And even they can even make that request with respect to their healthcare plan. That's only going to apply to conditions where the patient is paying out of pocket to begin with. But there are cases that come up in the addiction treatment area where a patient does not want to use their health insurance for certain reasons because they don't want their addiction treatment to be part of their medical record. As long as they're paying out of pocket, they can actually request that information be withheld from their general medical record. There's some nuances of this, and I would encourage you, if you get this kind of request, to speak to an attorney or someone with expertise on how to govern this. But it's something to take seriously, if it does come up. Okay, so let's move on. We've talked about, sort of one of the major buckets of HIPAA compliance, which is privacy. Now let's talk a little bit about our responsibilities as organizations in terms of security and safeguarding PHI. So in a general sense, the HIPAA regulations require that we safeguard PHI at all times. So, any kind of covered entity is going to be expected to protect against any reasonably anticipated, use and disclosure of PHI that's not permitted. And that means that the confidentiality, the integrity, the availability of ePHI that the covered entity creates or it receives or maintains or transmits. And so it may be the case that you have health information that you as an organization didn't produce, but that's given to you in the course of treatment. Again, that's going to be something that you need to safeguard as well. So within that, sort of big bucket of HIPAA security, there are sort of three smaller divisions into different kinds of safeguards. And that's, I think I mentioned them before, administrative safeguards, physical safeguards, and technical safeguards. So let's talk a little bit about what constitutes all these things. And again, it would be too specific to speak about, exactly how you accomplish all of these things in the scope of this 1 hour presentation. But, these are areas where very often, if you're extensively using any electronic system in your healthcare facility or addiction treatment facility, you want to make sure that even over and above any kind of legal or compliance advice that you're seeking, good IT security advice with different, your IT team or your security experts. So, here are sort of the general categories of things that fall into each bucket to which you should be sensitive. Number one, let's talk about administrative. So that's going to be your policy, your organizational policies and procedures that relate to HIPAA privacy and security. You want to make sure that you've got a set of those that are good, that actually tell your staff how to address and how to deal with, both the sort of thou shalts and thou shalt nots areas of HIPAA. You want them to be clear and not ambiguous, and you want staff to be able to access those policies and procedures for guidance when they're needed. Training is another part of the administrative safeguards like we're doing today. Again, you want to make sure that your staff, whether it's during onboarding or whether it's during, I would say, again, not less than a year at a time in between trainings, but that people in your organization are trained and specifically on those policies and procedures and their applicability to your organization. Things like having defined employee access to PHI. So we talked about minimum necessary. What you want to make sure, and this can be accomplished in an electronic way. And in terms of physical PHI, just with locks and keys, is everybody in your organization does not necessarily need to have access to every bit of PHI within the organization. To use sort of a cliche term, access to PHI should really be on a need-to-know basis. And make sure you have the infrastructure set up that allows that to be the case. A couple of other things, contingency plans in case of emergencies. Depending on where you live, you may have hurricanes, fires, earthquakes, all sorts of things, and even just things like power failures or computer glitches. You're housing healthcare information that may be very important to treat a patient or a client. You want to make sure that you have safeguards in place in the case where your systems go down or because of natural disaster or anything like that. That could be backup systems, redundancies, et cetera. Last bit of that is your business associates agreement. Again, we sort of talked about that at length, but make sure you have those in place for all your business associates and that they're you understand what they say and that they in fact do say what you want them to and you intend them to. So that's basically the category of administrative safeguards. And again, beyond the scope to really delve deeply into each element of those today, but my purpose is really to sensitize you as to the important areas of each, and so that you can ask the right questions when you talk internally within your organization about how you may be addressing those. So let's talk about physical. So that's things like, obvious things like locked file cabinets and visitor sign-ins and limited access. Things like shredding PHI that's no longer necessary, making sure that when you dispose of something that it's disposed of in a correct way. Simple things like workstation security. Don't have things facing out your window or to the public that's going to contain information that you don't want people to be able to access or see. A lot of these things are obvious, but they're worth making part of your training to your staff because it sensitizes them to this. And a lot of times, the things that are very obvious, we can sometimes think about less in an ironic sense. So let's talk about some technical security aspects. So, one is password protection. Shouldn't need repeating today to have robust passwords. Don't make them password 123. Don't have them in a sticky note on your, computer monitor. Make sure that you have a situation in place where if there's PHI on your computers that after a certain amount of time, those screens lock if someone leaves to lunch or goes to the bathroom, an automatic log off. Make sure if you're transmitting PHI that you have encryption and decryption mechanisms in place. Again, too detailed to go into how exactly you do that, but those who, work with you on the IT side are going to know what to do. Back up your data, have identity authentication, and have protocols in place. And this should really be part of your policies and procedures regarding the introduction and removal of hardware and software in your network, if you're a covered entity. A lot of this stuff is not that complicated, but you should be sensitive to it and make sure that it gets done, and it gets done correctly within your organization. So let's move on a little bit to breaches and reporting penalties. So, first of all, let's talk about what a breach is. And, what I would say is, number one, if you're in a situation where you think a breach may have occurred, within your organization, there should be a hierarchy of people to talk to about that. Before we even get into any of the details of this, resist the urge to, kind of cover something up or bury someone. It's sort of human nature. None of us wants to get blamed for something. The reality is that most breach situations can be resolved fairly quickly and easily with a minimum of, any kind of liability or, financial impact or anything along those lines, if they're dealt with early and transparently, and you get the right people involved. That's something, of course, we all struggle with, because you might be tempted to say, oh, well, I sent that fax to the wrong person, not sure who got it, but no one's ever going to know. I'll just leave it alone. It's not the way to deal with that situation. That's actually a common situation. It's a easy situation to resolve. It's an easy situation to document. And if you don't resolve it the right way, which might take you 30 seconds in the onset, you may be resolving that in 6 months with lawyers and litigation and a complaint investigation against your organization. So, resist the urge about that. So let's talk about definitionally a little bit what a breach is. So, any kind of unauthorized acquisition of data that compromises the security, confidentiality, or integrity of personal information maintained by the covered entity. That's going to be what a breach is. Improperly using or disclosing PHI, whether it's by a staff member or a vendor, if you violate HIPAA laws or state laws and, even your own policies and procedures, that can constitute a breach. But basically, any kind of impermissible use or disclosure of PHI is presumed to be a breach unless your organization demonstrates there's a low probability that the PHI has been compromised. And what I will tell you is that is going to be the case in 9 out of 10 situations where you have an accidental breach. That might be, I gave the example with a fax machine. That might be you send an email with PHI to Sally that really should have gone to Susie. Now, in an ideal situation, that information would have been encrypted, so it wouldn't have mattered whether it was sent to the wrong person, because the recipient wouldn't have had an encryption key to be able to open it. But even if that were not the case, you can pretty much determine relatively quickly that there's a low probability that the PHI has been compromised, because you probably know Sally or Susie, I forget who the inadvertent person was, and you can call her and you can say, please destroy that. Can you confirm to me that nobody viewed that or is making use of that PHI? And can you send me, a written confirmation of its destruction? And that's true. Very easy ways to address and solve these problems. And doing that kind of analysis is what's called a risk assessment. And you should do a risk assessment for every potential breach, no matter how small. The things that you want to measure are, what was the nature and extent of the PHI involved? One question might be, we think we had a breach of something, but we're not even sure whether what was, inadvertently disclosed even constitutes PHI. First question to ask. Whether the person who used the PHI, who that was. Were they an authorized person or a non-authorized person? Are they kind of friend or foe? Is it someone who you faxed it to a wrong hospital or medical practice? Probably an easy situation to solve. Again, whether the PHI was actually acquired or viewed. If you have the right things like encryption in place, the answer to that is going to be no. The answer to that might be no as well, depending on who you sent it to. And you can make those kinds of determinations. And then the extent to which the risk to the PHI has been mitigated. It might have been viewed, but if it's to a medical practice that you have a long history with and a working relationship with, the answer might be asking them to destroy it and ensuring that no one is going to make use of that PHI. Again, all that is going to be part of your risk assessment, and that's going to make a difference that, whether or not you have an actual breach on your hands. Other things to consider is breach exclusions. So, you can have an internal breach exclusion, which means, technically you might have a breach, but if there's unintentional use of PHI by our workforce member, that doesn't constitute a breach. You can have an external inadvertent disclosure, by a person who's allowed to access PHI to another person allowed to access PHI at the same entity, but it might have just been the wrong patient. Again, that's going to be a breach exclusion. And then the third is going to be information that can't be retained. So, if you believe that the party who accessed the information just wasn't reasonably able to obtain it. So, for example, a visitor comes in and assists someone in your staff in picking up a chart that was dropped on the floor. Well, there's no way that visitor retained any of the information on that chart. You don't have a breach. So let's talk a little bit about breach reporting. And I'm not going to go into too many of the specific details here because breach reporting is complex. If you do have a situation where you have concern that there's a breach, I would very much encourage you to seek legal counsel or seek competent advice from someone with expertise on the proper way to report things. There's going to be different rules in effect depending on your locality as to how long you have to report a breach, when you have to report a breach, etc., etc. And you want to make sure you get that right. Obviously, you don't want to over-report because you don't want to report something you don't have to. It looks bad for you, and it can be public and increase your liability. By the same token, you don't want to under-report and not report something and then have that come back to, hit you because, If you fail to report something that you should have, then you're really talking about fines and penalties. And, that's when the stuff you read about on TV or on the internet really comes into play. One thing to keep in mind is breaches by a business associate. In your business associate agreements, there is going to be an allocation of liability for that. And there's going to be requirements that your business associate notifies you immediately. And it's hopefully going to spell out that your business associate is directly liable, for its breach. So, make sure you are, again, with any of this, asking people the right expertise and documenting all these steps. Documenting the fact that you had a potential breach, documenting that you've done your risk assessment, documenting, how you've resolved that situation. If you have reported something, make sure you are going ahead and reporting it appropriately. Talk a little bit about penalties, and I won't get into specifics because, again, they change any time, and it's not really my purpose here to talk fire and brimstone. But even with unintentional breaches, you can get into a situation where they're $100 per violation, and unfortunately, we live at a time. Well, I should probably say, fortunately, we live at a time where a lot of health records are electronic. And that's really been a game changer. And the reason for that is the following. Back in the day when almost all PHI was paper-based, there was kind of a limit to how much, mischief you could get into. If you made a mistake, one patient's PHI, two patients' PHI, let's say you took a couple of files home and you misplaced them. Today we live at a time because of, technological savvy and progress that you could hit the wrong button and, 50,000 patients or clients' PHI gets distributed somewhere, or through, a network tack or something like that. That's kind of raised the stakes a little bit. And even, inadvertent breaches can be a minimum penalty of $100 per individual affected. And, when you're talking about 1,000 or 2,000 people, doing the multiplication, that can be a very high number relatively quickly, even for sort of a minor incident. So, that's really all I'll say about fines and penalties. So let's move on to 42 CFR Part 2. And this is an area where, from people in the addiction treatment space, I get a lot of questions about. So a little bit of background. So back on January 18th, 2017, a final rule was released, which updated the regulation regarding the confidentiality of alcohol and drug abuse patient records. Kind of the first meaningful update in the last 30 years. For a while, it was actually halted by the Trump administration and then later fully implemented. Essentially what this 42 CFR Part 2 does is it's an in addition rule to HIPAA, and it requires specific consents on the part of the patient, except for in very limited circumstances. If the patient records have to do with alcohol or drug abuse. So it's a little bit of recognizing that the issue that we talked about earlier, which is that these are, this information is very sensitive and perhaps even more sensitive than general health information. The government moved forward on this. So let's talk about to whom and what 42 CFR Part 2 applies. So it doesn't apply to everyone, and in fact, I think it probably applies to a very small segment of the addiction treatment community. So information is protected under Part 2 if it would identify a patient as having had a substance use disorder, either directly by reference to publicly available information or through the verification of information by another person, and is obtained by a federally assisted drug abuse program. That's called a Part 2 program. So we got to talk about what the definition of this. And again, the application of whether your organization is part of a Part 2 program, that's sort of the colloquial term for it, can be technical. I certainly can't give you legal advice in this forum as to whether or not you're part of a Part 2 program. So seek competent counsel about that and expertise. But I'll tell you just sort of the general outline of it. So a Part 2 program holds itself out to provide substance abuse disorder treatment and is either conducted either directly or by contract by a federal agency, carried out pursuant to a license or certification or registration granted by a federal agency. So, for example, Medicare providers. It can be a recipient of federal assistance, either directly or indirectly, or conducted by a state or local government which receives federal funds, or is a tax-exempt entity. So 401c3 would fall under this category. So, again, those can be pretty complex in application. You may already know whether or not you're subject to 42 CFR Part 2. If you're not, the good news is that this isn't going to directly apply to you, although it's always a good practice to sort of, keep some of these strictures in mind. But you can sort of coast through the last couple minutes of this presentation if it doesn't apply to you. But let's just talk about the sort of patient consent overlay of this. And, again, 42 CFR Part 2 is sort of a longer set of regulations. I'm kind of just hitting on the highlights, but, if you're subject to them, you should, seek the right expertise to talk to someone about how to implement these regulations in your organization with a little more specificity. But, that said, let's talk about them in general. So previously, we talked about a consent for disclosure and, what that constituted early on in this presentation. And so previously, for a consent to be valid, you would have to designate each individual entity to whom a disclosure could be made. So a couple of things that have now changed is a patient can now consent to disclosures to all of his or her treating providers without naming one. But if a patient designates it, the patient has to have the option to request a list of the people and entities that received his or her records. So you're going to have to keep that on their behalf. Additionally, the amount and the kind of information shared has to be more specific. So patients can consent to disclosure of all of their substance use disorder records, but they also have to be given more granular options, such as medication, substance abuse history, employment information, or living situations. And those options have to be specific enough for the recipient to identify the information necessary for its stated purpose. So, a couple of other things, redisclosure of information that may identify a patient is going to be prohibited. Without a consent, protected records can only be disclosed in certain situations, like audits and evaluations, research and medical emergencies, and to an entity that provides services like legal, accounting, population health to a Part 2 program. So again, those are some pretty specific exceptions, and you have to consider very deeply what applies. One thing to keep in mind as well, just like HIPAA, if there are state laws that are stricter than 42 CFR Part 2, they're not preempted. So meaning you have to follow those state laws as well. So again, whatever locality you might be in, make sure you're aware of of what applies to you. So, there's still, I would say that coordinating privacy concerns and care, one of the things that I think comes out of this presentation is a persistent challenge. On one hand, you need to be able to disclose and disseminate and use protected health information to effectively treat your clients and patients. On the other hand, rightfully so, there are many kind of protections that apply, and it's often a challenge to strike the balance necessary to sort of respect both areas of concern. I hope that this presentation has been helpful. Again, this was designed to really give you an overview and a flavor of a lot of the pertinent areas of HIPAA privacy and security, as well as 42 CFR Part 2 that applied in the substance abuse community and to substance abuse treatment organizations. If you have specific questions, you're welcome to write into me or to seek them from other competent experts that you may already have access to, and I would encourage you to do so. So I hope you've enjoyed today's presentation. Thank you for your time and attention.
You've just finished listening to another exclusive continuing ed podcast by Clearly Clinical. If you like what you just heard and you need continuing ed credits, please visit us at clearlyclinical.com to check out our one-year membership, where you'll have access to our growing library of continuing ed podcast courses. Clearly Clinical, where our goal is to help you learn, grow, and shine.